Very good afternoon, everyone, and welcome to NITYA Legal Monologue. Today, we are going to discuss a very important topic of transitional credits. In my last session also, I had taken up this topic when the Supreme Court judgment had come. There is further development now. We are now having the CBIC guidelines, a circular issued by CBIC, wherein they have prescribed certain guidelines for the applicants with respect to transitional credits. So, as we all are aware that there was an earlier regime of excise, service tax, VAT, from which we transitioned to GST and all those taxes got subsumed. Resultantly, whatever credits that were available had to be transitioned to GST regime. Now, this posed a major problem because in the earlier regime, the credits were validly availed. Those were available for utilization for setting off the output tax liability under that regime. Once GST came in, there were portal issues, there were several glitches, there were procedural glitches, technical glitches. Taxpayers were not aware it was a new regime, and therefore multiple issues came up. Also, GST provided for certain transitional provisions, section 142, 142 of the GST law, as also rules 117 to 121. They made provision for the transitional provisions, how to transition credit. But those were not exhaustive. They did not exhaustively cover each and every situation. There were far more situations that the taxpayers faced, which were not contemplated in the law, or there were certain issues which were completely beyond what the law prescribed. And therefore, multiple writ petitions were filed before various high courts. There were hundreds and hundreds of writ petitions that got disposed of, most of the writ petitions in favor of taxpayers. Now, these matters ultimately traveled to the Supreme Court. So, in cases where taxpayers won, the Union of India went to Supreme Court. In cases where Union of India won, taxpayers went to Supreme Court. Now, recently, Supreme Court wide order dated 22nd July 2022 disposed of all the matters and gave certain guidelines. I'll just discuss those guidelines or the decision of the Supreme Court. So what Supreme Court did, Supreme Court kept all the legal issues open. Those were not decided. Supreme Court directed GST network to keep the portal, common portal open for filing or for revising Tran 1 or Tran 2 forms during the period October 1, 2022 to November 30, 2022. So for the month of October and November 22, the portal shall remain open when all the aggrieved registered assessees can either file Tran 1 or Tran 2 if they have missed out, or if they want to revise the already filed form Tran 1, Tran 2, they can do so, irrespective of whether they went in appeal, whether they went in writ petition, whether their case was considered or decided by Information Technology Grievance Redressal Cell of GSTN. Also, Supreme Court directed GSTN to not to have any glitches, technical glitches during this period in the common portal. Supreme Court further gave 90 days time to the revenue officers to pass an order on merits allowing or not allowing the credit. And this needs to be done after affording reasonable opportunity of hearing to the taxpayers. And whatever credit the officers will allow will then get reflected in the electronic credit ledger of the taxpayer. Also, Supreme Court directed GST Council that it can consider issuing appropriate guidelines to field formations, to the officers for scrutiny of claims, how they will scrutinize the claims. Now, since the Supreme Court and thereafter, initially Supreme Court had given direction from September for the month of September and October, Union of India sought extension by 4 weeks, and by order dated 2nd September 2022, Supreme Court granted that extension, and so the portal now needs to be opened from October to November 2022. Another aspect is that after the Supreme Court order, there has been no GST Council meeting. Therefore, GST Council has not made any recommendation to CBIC or to any state government for issuing any kind of guidelines or circulars. Yet, CBIC on its own has issued a circular on 9th of September 2022, which is last week. This has been issued under section 168(1), which provides for issuance of guidelines to the officers for uniformity, to ensure uniformity in implementation of law. Now, while the section provides that guidelines can be issued to officers for uniformity in implementation of law, what the circular seeks to do is it gives instructions to the applicants, to the taxpayers, or the aggrieved registered assessees who wish to either file Tran 1, Tran 2 or revise their Tran 1, Tran 2. So this circular has the implication on the applicants. Now, circular definitely provides that the portal will be open for filing or revising Tran 1, Tran 2. Fresh filing revision is allowed. Circular also prescribes that a declaration in Annexure A has to be uploaded. Now, this is a new development. This Annexure A is not provided either under the GST law, nor Supreme Court has given any such direction. And therefore, this is a new development wherein the details have been sought in Annexure A by CBIC. Also, CBIC has put a lot of restrictions. One such restriction is in table 5B and 5C relating to statutory forms under VAT, Form C, Form F, Form H, Form I, which are issued on or after December 27, 2017. So they put a cutoff date that after this date of 27 December 2017, if any form is issued, then the details of the same cannot be captured in table 5B and 5C of the Tran 1 form. So this is a restriction that has come. Also, what the circular prescribes is that in relation to inputs, where the person was earlier unregistered and he's claiming credit of inputs based on invoices available or without invoices, then he has to dispose of those inputs, and within 6 months, whatever goods are disposed, he has to file Tran 2 every month. So what circular also clarifies is that this Tran 2 should be a consolidated claim, and only the last month of Tran 2 of that month needs to be mentioned, and not of all the 6 months. Another point that the circular prescribes is that in case of table 7A of form Tran 1, where a credit transfer document needs to be uploaded in form Trans 3, then that can be done. Lastly, the circular also says that this is till prior to submission of form Tran 1, the form can be edited, but once it is submitted, then the form will freeze, no further changes will be allowed. And in this regard, the detailed technical advisory will be issued by GST network. So what is the procedure? The procedure is that step 1 is you file or you revise your Tran 1, Tran 2. If you have not filed earlier, you have to file it fresh on the common portal. If you have already filed, then that form will be available to you for download. You can download it and it will be editable. You can edit your form. Also, within 7 days of filing the form, you have to submit physical copies of the self-certified copy of Tran 1, Tran 2 that you will file now. You have to file Annexure A, which the circular has prescribed after due declarations. And also, as I mentioned, relating to table 7A, the credit transfer document in Trans 3, that also needs to be filed. Now, a verification will be undertaken by the officers, and for this they may require you to furnish the documents, records, returns, invoices, etc. to substantiate your claim for the credit. A hearing will be given by the officer concerned, and after that, within 90 days of filing the form, an order will be passed by the jurisdictional tax officer allowing the credit or disallowing the credit, or partially, depending on what the order is. And to the extent the credit is allowed, that will get reflected in your electronic credit ledger. If any credit is disallowed, definitely you will have option to file appeal as per the GST law. So another important aspect here is that what is this Annexure A? What requirement, what kind of declaration does it require? it requires you to provide details of earlier filed Tran 1, Tran 2, which should contain the date of filing, the amount of credit claimed in the original form Tran 1, Tran 2. If you have not filed earlier, obviously this detail will not be relevant for you. But if you have filed earlier and you are revising it, these details need to be provided. These details as it is are available with the officers on the portal, yet they are seeking this detail again. Another detail that is being sought is the for the taxpayers who claimed their transitional credit through GSTR 3B. So multiple cases, we have seen that either the High Court in the writ petition directed the taxpayers that they can avail the credit in GSTR 3B, or the taxpayers on their own availed credit in GSTR 3B. Now, this could have been, there can be situations where taxpayer never claimed in GSTR 3B, or they claimed in GSTR 3B but reversed the same with interest, or there can be a situation where they claimed in GSTR 3B but they never made any reversals. So whatever the situation is, the department wants to know as to what is the correct position, what is the factual position in this case. Now, what can be the purpose? Now, this is not flowing from law. This is not coming from GST law or from Supreme Court directions. Yet the CBIC circular is requiring it. The only logical conclusion that one can arrive or reach at is that after the order is passed, and if the officer feels that a taxpayer has claimed in GSTR 3B, has neither reversed and nor paid any interest, and some part of that amount claimed through GSTR 3B is found to be ineligible, then to that extent the officer can raise a demand with interest, penalty, etc. However, if the in the order that the officer will pass, if he allows the credit and he sees that this amount has already been claimed in GSTR 3B, either he will regularize that 3B and will not allow any credit to be reflected in electronic credit ledger, or he may ask the taxpayer to reverse the credit in 3B with interest and then credit the electronic credit ledger. Now, in this regard, the position is not yet clear. There is the circular is silent as to what will happen in such cases where the officer finds the credit as eligible in his order, and yet that credit has already been taken in 3B. Then what will the officer do in such a case? Whether he will ask reversal and then recredit the electronic credit ledger, and what will happen to the interest part in such a situation. Next is the circular seeks details about the refund claim, and this they are seeking under the erstwhile law, existing law. So either what the logic behind this could be that the officer must know that there is no dual benefit to the taxpayer, in the sense that taxpayer has already claimed some refund under the existing law and is also claiming credit under the GST law through transitional credit. So that should not happen. That could be the logic. However, the GST law does not provide any jurisdiction for the officer to venture into the existing law provisions or existing law related facts. So here the circular seeks details about whether any refund claim was filed or not filed. If any refund claim was filed, whether any refund has already been granted to the taxpayer under the existing law, and an undertaking that taxpayer would not file any refund claim. So this detail in our view is beyond the jurisdiction of the officer. Another detail that they are seeking, again pertaining to the existing law, is the whether under the existing law either any credit which is being transitioned to GST has already been utilized or adjusted against any demand or liability. So what has happened is that in most cases we have come across, as on 30th June 2017, there was a closing balance under existing law. Based on that closing balance reflected in the returns, the taxpayers filed their Tran 1, Tran 2, etc. in the existing in the GST regime and transitioned their credits. Now later, the existing law, the assessments were undertaken by the whether state VAT authorities or by the excise or service tax divisions, and certain demands were created, and those against those demands, the credits that were existing in the earlier period were either adjusted or those credits got utilized. And therefore, effectively on 30th June 2017, those credits did not exist. So the authority, it appears that CBIC through this guideline or this circular is seeking the details of such credits which got utilized or adjusted so that there is no dual benefit. While the logic appears valid, but again, as we saw in case of refund, the authority has no jurisdiction to look into the fate of credit under the existing law. Also, declaration is being sought about the pending disputes under GST law. So in this regard, what the officers are seeking, this circular is seeking, is whether any show cause notice or any orders have been passed under section 73, 74 with respect to the transitional credit. Also, whether any such credit has been held to be ineligible, whether any appeal writ petition has been filed, what is the status as on date of the same. So essentially, they want to know the pending status of litigation under GST law with respect to the transitional credits. Now, this recovery provisions come through Rule 121. We will not go into the detail that there is no substantive provision for transitional credit under section 73, 74. It is only through Rule 121 that they seek recovery. So having said that, this detail about the pending matters is as it is available with the officer on the common portal, because common portal has all the details of pending show cause notices, etc., in respect of any assessee. However, they are seeking the same details again from the taxpayer in the form of annexure declaration in Annexure A. Also, they are seeking pending dispute details under the existing law. So again, there is no jurisdiction that the authorities under GST law have, yet they want to know through this circular and in this declaration form, what are the pending show cause notices or orders that were passed and what credits were held to be inadmissible. Now, question is that any credit, the authorities should only look at the closing balance in the returns as on 30th June 2017 or other parameters under GST law for transferring credit. What happened in the previous regime, whether that credit was validly availed or was admissible or inadmissible, those disputes cannot be gone into. And therefore, to this extent also, the requirement or the demand or the information that is being sought is beyond the jurisdiction of the GST officers. So we come to the way forward. First and foremost is that the taxpayer must reconcile books of accounts and check all the missed credits. These could be on various accounts, and we have seen that taxpayers came to know much later about those credits or about the adjustments. There can be reasons with respect to filing the earlier Tran 1, Tran 2 in wrong column. Some taxpayers, because of excise free zone or for other reasons, they transitioned they were not registered under central regime, they were only registered under VAT. They transitioned their central taxes also under state tax, and therefore there are multiple reasons where errors happened while those credits were valid, yet now they need to reconcile and file correct, declare correctly all the particulars to avoid any kind of dispute. There are disputes relating to ISD. There are disputes relating beyond 12 months claiming of credit on inputs, etc. So multiple disputes are there. Those need to be kept in mind. Also, it is suggested that earlier, while it was a self-assessment under Tran 1, Tran 2 initially, but now it will be through verification process through passing of order. So there will be no issue of any interest penalty, and therefore it is suggested that whatever block credits are there, those should also be availed. Let the officers reject it, and then the taxpayer can litigate it. But keep your keep your right open, because multiple issues are pending. For instance, the credit of cesses, whether that is eligible or not, that matter is pending before the Supreme Court. So let that matter get decided there, and if it is allowed in favor, you will get the credit. If it is not allowed, there is no downside to it. Also, similarly, ISD related issues beyond 12 months, all legal issues have been kept open by Supreme Court. So those issues must be must survive, otherwise you will lose your right. So you must take those credits and then litigate. All the forms wherever the errors happened earlier must be rectified. Like I said, assume for a minute that you had credit in your closing balance on 30th June, and based on that you filed your initial Tran 1, Tran 2. Later you realize that based on the assessments that were undertaken under the existing law, certain credits got exhausted in the utilized or adjusted against that demand. So eventually your closing balance got reduced. Now you have to mitigate, and that the authorities are disputing that. They are even they have come to the extent that they are seeking information, and they have suggested in this circular that if you already have filed your Tran 1, Tran 2, and there is no error there, or any show cause notice or any litigation is pending, then you follow the litigation route. In our view, that is not the correct approach. If there are any revision that you need to make, you now are aware that yes, you can rectify that form and mitigate that dispute, then definitely you should file a revised Tran 1, mitigate that dispute, and tell the authority wherever the litigation is pending under the GST law that you have already rectified your mistake in the form. The revised form is you should produce, and therefore the show cause notice or the whatever the order, etc., is not tenable, that needs to be dropped. So that is what you should be doing. You should bear in mind that this is only a one-time opportunity, for the last time that this portal will be opened. So you must be very conscious that you avail this opportunity, not make any mistakes, and adhere to the timelines, because 30th of November is the last date. We come to the open issues, some of the open issues. One is that the circular seeks to block transitional credits, whether such blocking is legal. As I said, the circular itself ought to have been, it is issued, it is not under the recommendations of GST Council, which was provided by Supreme Court order, but CBIC has issued on its own. Secondly, CBIC has issued this circular under section 168(1), which is not the correct provision for issuing to the taxpayer. Now, 168(1), they could have issued directions to their officers for uniform implementation of GST law. But as we have seen, they have issued circular giving directions to applicants, the assessees. Also, they have introduced new declaration under Annexure A. Also, they have tried to block certain credits. So the circular does not appear to be legal. They have blocked credit based on pending litigation under GST law, under erstwhile law, based on statutory forms that we have seen, credit of cesses as we have seen, also the fate of taxpayers who claim credit in 3B, that is also not clear, and they are seeking to probably block that, especially where they disallow credit to some extent, it appears. Also, issues relating to ISD, as we saw that after the Supreme Court judgment, there are a couple of judgments from Bombay High Court in the case of Unichem Laboratories and Colgate Palmolive, where Bombay High Court gave directions to the GST Council and to CBIC to open the portal and allow these credits also. So ISD credits, in most cases, ISD transitioned credit to GST and thereafter transferred credit to the units. And what the authorities were of the view that no, ISD ought to have transferred credit to the units first under the pre-GST regime, and then respective units should have filed Tran 1, Tran 2 for transferring credit or transitioning credit to the GST regime. So these issues, while the credit is not under dispute, only dispute is technical or the procedural aspects. And courts have come to rescue that these should be regularized and should be done away with. Likewise, beyond 12 months, the Filco trade judgment itself, the Gujarat High Court, which later traveled to Supreme Court, the Gujarat High Court held that this condition is ultra virus. Of course, there is a Bombay High Court adverse judgment also, but Gujarat High Court distinguished the Bombay High Court and still held that 12-month period, which has been prescribed for availing credit of inputs in Tran 2 is not valid. Therefore, it's ultra virus. So all such cases need to be addressed, and all these credits must be taken and litigated. Also, there are issues relating to the technical clarification, which is yet to come from GST network as to how Tran 1 or Tran 2 revision will happen and what procedures they will prescribe is yet to be seen. So these are the major issues. These are the major points that we thought we will cover in this, because the time we are right at the brink of October. We are already in September mid, and October 1st the portal will open, and our recommendation is that all taxpayers must evaluate their books, look for the credits missed out. In this regard, while we at the time of registration we had floated a poll query also, wherein we had asked that if you have missed out on any transitional credit while filing Tran 1 or Tran 2, and there was a response. What we received is that at least 33% of the taxpayers, they said that yes, they have missed out on credits while filing initially Tran 1, Tran 2. 60% were of the view that they have not missed out, and remaining 7% were of the view that they need to check their accounts and books of accounts to come to this. So at least 33%, more than 1/3 of the taxpayers, they either missed the credits or they filed under wrong head or wrong table, etc. Or the position changed over the period, as we saw that because in the past 5 years the assessment of previous period had taken place, or there have been new developments that had happened which would now require revision of Tran 1, Tran 2. So it's a golden opportunity, one time opportunity which taxpayers have, and they must avail this opportunity. So that's about it. We'll keep our fingers crossed how the GST network, what guidelines they prescribe on the procedural side, and what new other guidelines that come from states, and whether GST Council, which is scheduled to meet sometime in September itself, whether they come out with any guidelines in terms of the Supreme Court order. So October 1 is very near. If you still have any queries, if you still feel that there are any doubts, please do feel free to reach out to us, and we'll be happy to take up. With this, we end our session. Thank you very much for attending in such large numbers. Thank you.